In early 2017, the Trump administration indicated its intent to review, revise, or rescind the Clean Water Rule. Now, various exemptions can apply to exclude wetlands from the federal government's jurisdiction. Under the Clean Water Act, and one is prior converted cropland. That's what we're going to be talking about for today. Joining us for our Rural Money segment is Kansas Farm Bureau Professor of Agricultural Law and Taxation at the Washburn University School of Law, Roger McEowen. Thanks so much for joining us, Roger. So how does the prior converted cropland exception apply?
Well, good morning, Christina. And this is a big exception for farmers because, and rural landowners in general, because there are about 53 million acres of prior converted cropland in the United States. And this exception to Clean Water Act jurisdiction by the federal government, by the Army Corps of Engineers and the EPA, dates back to the 1985 Farm Bill that brought in the concept of swamp buster. And under that provision, there was an exception that was created for purposes of the swamp buster rules, which said basically if you break out land that is wet and farm it, then you're caught under the swamp buster rules. But if you had commenced conversion, you were exempt from swamp buster if drainage work had begun before the effective date of the 85 Farm Bill, and that was December 23 of 85. And that's the genesis of the prior converted cropland exemption. And the only way you lose that status is by abandoning the farm use of that property, and that can occur after 5 years of inactivity, and it can also happen in 1 year if there is intent to abandon. And what happened was, later on, the EPA and the Corps adopted the USDA prior converted rule, and so it's also part of the Clean Water Act.
Okay, now we're always looking for the best feasible solution. Is there a better way for the federal government to regulate prior converted cropland than the present manner that we're working with?
Yeah, this is one of these interesting ones where you have USDA and EPA and the Corps all involved, and the EPA and the Corps adopting a USDA rule, but it's basically administered for purposes of the Clean Water Act by the EPA and the Corps of Engineers. In my view, and this is just my personal opinion, I think it's probably best to have sole regulatory authority vested in the USDA. They have 30 years of experience with this exemption and an office in practically every rural county in the United States. So to me, it would seem that it would make more sense that sole regulatory authority of prior converted wetlands would rest within the USDA.
Okay, now we want to read more about this. Can we find it on your blog?
I did do a blog post on this just Monday of this week because there's a brand new Illinois court case coming out of the Chicago metropolitan area involving not a farmer but a developer that had purchased 100 acres of land to develop. And the question is whether that land had been, whether farming had been abandoned such that the feds now have jurisdiction and it's no longer prior converted cropland. Big issue that's out there, and that's the most recent case.
Absolutely. And I love being able to go through your blog post with a fine-tooth comb and read and reread to really get a grasp of what you're going to be talking about. So thank you so much for breaking it all down in layman's terms for us. Kansas Farm Bureau Professor of Agricultural Law and Taxation at the Washburn University School of Law, Roger McEowen. We really appreciate you joining us.